Hi guys, welcome back to the channel. So if you have received a letter of inadmissibility, a ban letter from the Government of Canada, from RCIC, without first receiving a procedural fairness letter, you must need to act fast, and this video will tell you how to act faster. My name is Niladri Mukherjee. I am a regulated Canadian immigration consultant, and as an organization, we predominantly deal with responding to the procedural fairness letter, responding to criminal inadmissibility, and anything that deals with the complex nature of Canadian immigration. So, as a principle of natural justice, IRCC should always give you a chance to respond. If they are saying that, well, I have a problem in reviewing your application because I think that you must have hidden some information, you must have misrepresented something, and hence you will be banned. So they cannot put you a blanket ban on you without giving you an opportunity to let them know you are part of the story. Now, if they're saying that, well, you have misrepresented something, they could be right, but you should be given a time window to tell why did you do that. Was it intentional? Was it unintentional? Did you hire somebody, an agent who did it on your behalf? Whatever the story is, you should be given an opportunity. But if you have directly been given a letter of inadmissibility without a PFL, that is fundamentally against the principle of natural justice. But it is not very uncommon to see it coming from the various parts of Central Asia as well as Middle East. Particularly, it could be from anywhere else as well. But at least my experience says that those are the two regions from where we get to see a lot of this kind of a letter. You must understand that that's not following what the immigration law says, what the regulation says. If somebody has done it, if one particular IRCC has done it, the very first thing you have to do, and you really have to act sooner, faster to do it, is to apply for a reconsideration of the decision. Because giving you a refusal of that application, refusing your application, is altogether a different thing rather than putting you a blanket ban without an opportunity to respond. It's very important for you to understand is that in that reconsideration, we are not trying to ask them to reconsider the file and giving you an approval. What we are saying is that you did not follow a properly laid down process. You did not follow the principle of natural justice. You did not follow the principle of procedural fairness, and this is completely discriminatory. If 99% of the people have been given procedural fairness letter, and then whatever decision comes in, and if particular 1-2% of the people were not given a PFL first and then they're given a decision directly, which is an inadmissibility decision, that is highly discretionary, and hence you have all the right to apply for a reconsideration. A couple of things to keep in mind here is that you need to act faster. You cannot just sit on it for a period of a couple of months and then come for it. It won't work. You can certainly send it, but the possibility of success in those kind of lags are very, very low. So you have to keep that in mind. Typically, in my books, you should be having a reconsideration of those nature ready within a maximum of weeks time of you getting a letter of inadmissibility. If you get the letter on 5th today, 5th of December, you should be able to send a reconsideration request maximum by the 12th. And the reason I'm saying 7 days is because it does take time to understand how it works and then send it. Maybe include a couple of case laws, maybe remind them how the principle of natural justice process should be working and how did they not follow that. Those processes, those preparations take a little bit of time. But if you're able to prepare a document in 2 days, send it in 2 days. The point is, don't wait a very long time. That diminishes the credibility of the overall reconsideration application, at least from my experience. For a reconsideration request, if you're hiring a professional, you have to pay his or her legal fee, but you do not have to pay any Government of Canada fees. Because you are not paying any fees to the Government of Canada to reconsider this decision, this type of reconsideration decisions, applications become very, very discretionary. If an officer likes to reopen your file, he or she may. If he doesn't want to, he can very well not open that file altogether. Having said that, except for a very few specific IRCCs in very specific countries of Middle East, I see most of the IRCCs are ready to reopen the file, are ready to take a relook at the file, and in majority of the cases, at least, I see a positive decision coming in terms of lifting over the ban. For sure, it could be an application refusal. I cannot comment on the merit of that application if I'm just taking care of the PFL part. But application approval, application refusal are very two different things as compared to getting a ban, getting a letter of inadmissibility. So that's what I'm more concerned about when I see cases like this. But the good news is that if you're able to put together a proper reconsideration request well on time, the possibility of success is very high. Frankly speaking, I have also seen cases where it's taking months. Till date, I have been waiting for a reconsideration decision for a couple of my genuine clients who have been banned, but that's a very small percentage. To be fair, that's not very common. If you do not get a decision from RCIC after they have acknowledged your reconsideration application, you probably do not have much reasons apart from to waiting for the notes and to keep pushing for it. But there is a limit to which you can push for it, so you just have to be patient to wait for a decision. Again, that's a very small percentage. In majority of the times, IRCC is lenient enough to take a relook at the file whenever they think that there is a breach of the procedural fairness, because this is not normal, this is not fair, this is not just. The very term it says the procedural fairness, which means the process has to be fair. And if somebody is giving a ban on you without giving you an opportunity to respond, that's not a fair process, whatever that is. And hence, your voice needs to be heard. But you have to push for it. You have to build upon a case around it. You have to make sure a proper reconsideration request is being drafted, sent on time, so that IRCC is lenient enough to take a relook at it. We as an organization, we do this a lot day in and day out. If you need our assistance with this, book our relevant professional consultation. That's the very first step. Nuvonation.ca. It has got all the relevant information to it. Book a consultation directly through the website. I'll be more than happy to take a relook at the situation to tell you what you can do it by yourself, so that after the consultation, you're all set to do it by yourself. And if you need me to do it after the consultation, I'll be more than happy to help you as well. I hope this helps, and I'll see you guys in the next one. Bye now. Cheers.